Well, it's time now for 4CRB's Law and You program, and that means it's a good morning to John Fradgley from the Bell Legal Group. Good morning, John.
Yeah, good morning, Colin, and good morning, everyone out there in beautiful Gold Coast City. John Fradgley from the Bell Legal Group with you for the next half an hour right here on your radio station 4CRB for the Law and You, which means it's your opportunity to get free legal advice between now and 9:30. All we need you to do is telephone 55208888. That number again, 55208888. We do have an email address, talkback@4crb.com, if you need to send an email through. But as I say each week, we can't deal with emails that are received during the program. We will have to deal with those the week after. So if you intend to send an email, you will need to listen in next week. South of the border, or more particularly south of the Tweed River, don't forget you need to put 07 in front of our phone number so that it would be 07 55208888. Thank you to all the people who called in last week and made for yet another interesting program. You may recall that the program was opened with a call from Ruth, who was calling about her daughter who had just recently been through what sounded like a fairly formal mediation. And she mentioned 4 people, so it sounded to me as if it was probably her daughter and her lawyer, and then the husband and his lawyer. And apparently they reached agreement in relation to everything. But then a few days later, the husband decided that he was no longer in agreement. And I said to Ruth that I had some concerns about the enforceability or otherwise of that mediation agreement, not the least of which was because I don't practice in the area of family law. However, I did refer the matter and refer Ruth to one of the family lawyers here, Alex Wynn, who was able to speak to her in relation to the matter and get more of the chapter and verse of what occurred. And it appears that although it was a mediation, it wasn't a formal mediation in the sense that there was not a mediator who was presiding over it, and therefore it sounds as if the terms of the mediation were not then reduced to writing and signed off by the parties immediately. And the result of that, of course, is that Alex was advising that unfortunately the parties pretty much until the court sanctions the terms of the agreement are able to change their mind, which is quite unfortunate for Ruth's daughter and certainly unfortunate in the current circumstances. So just a little bit of a clarification. Ruth already had that information, but I was just passing it on this morning so that everyone was aware of that in case you had a similar question or a query.
John,
Colin, any calls?
We do. We have our first caller, and I'll introduce you to Barry.
Okay, Barry. Good morning, Barry. How are you today?
Is that John, is it?
Certainly is. How can I help you today, Barry?
John, just a question regarding a real estate where an agent produces a video to show the ins and outs and whatever of a property, and then nothing, because the vendor pays for that video, and then time goes by and it runs out, and then they decide to sell it themselves or go to another agent. Even though they own that video or they're paid for it, are they allowed to use that through another agent, or can the first agent then come back and say, you've used our property, so therefore we're entitled to 50% of the commission or something of that nature? That's the question.
Right. Well, first of all, you need to understand that who owns the important issue is who owns the copyright in the video. And so unless in the original agreement with the first agent there was, and it doesn't matter who pays for it, by the way, so unless there was an agreement, unless the agreement said that the copyright in the video will be owned by the owner of the property, is because the owner's paying for it, the copyright belongs to the owner of the property, then unfortunately the copyright in the video would remain with whoever produced it. And if the agent in fact used a if the agent in fact used a video company to produce it, then subject to the terms of the agreement between the video producer and the agent, that would then determine whether the agent actually owns the video or the person who produced the video owns it. So it's a very tricky question. It's much the same as the issue in relation to copyright in the plans for a house that are drawn by an architect or drawn up by a draftsman. Unless the agreement, engaging the agent, the architect or the draftsman specifically provides that the copyright passes to the person who engaged them to do the work, copyright remains with the person who produced it because it's an artistic work.
Good. Yes. Okay. I had a feeling that was pretty much the case. Much the same as when
that all being said, though, Barry, I don't think that would then mean that the agent would be entitled to 50% of the commission, simply because you've used the video to promote the property for sale. The question would be what damage the agent has suffered as a result of you using or someone using that video. So the first thing you've got to do is go back to the agreement that you had with the agent, and then there could be an argument. The agent might try and argue that because there is provision in a sole agency agreement, for example, that anyone introduced to the property during the term of the sole agency agreement, then you're liable to pay commission to the agent, even if the sole agency agreement has expired, if the person's been introduced during the term of the sole agency. So whether there could be any argument that the video was the cause of sale, that would be, I think it would be a difficult argument for the agent to run, but in these times when properties are not exactly selling exceptionally well, agents may be looking to anything possible to try and to try and make a buck. So, what would probably, if the video doesn't have anything on it identifying the agency, obviously if it has anything on it identifying the agency, then you definitely should not use it, because clearly then there could be an argument that they were the cause for the sale. The other alternative I would suggest would be to simply remake the video yourself, or have someone just remake it. They're not that hard to shoot even if you've just got an iPhone.
Using the original content without any identification of that agent.
No, what I'm suggesting is that you reshoot the video. So in other words, you remake it, so it's a brand new video. You can use the same, like you can shoot the same scenes of the house and all that sort of thing, but make it that you've made the video rather than the agent's made the video.
Okay, so getting back to the original question, the agent would find it difficult, providing it isn't somebody that's come from the interest in while that was a sole agency. He'd find it difficult claiming percentage of the commission. So, for instance, Joe Smith was the first fella, and then Billy Jones was the second agent who took this on, and then somebody totally foreign to the first agent, by looking at this video or being seen this video somehow, it'd be difficult for the first agent to claim, but there could be a claim from whoever has the copyright, such as the person who produced it. That would be correct. Yeah. Would that be right?
Well, that as I said at the outset on that, it depends on the terms of the agreement between the agent, the real estate agent, and whoever produced the video. So if they have an agreement with the video production people that the copyright in the video belongs to the real estate agency, then then obviously the agent does have rights in relation to the video. And the other thing too, of course, is whether there's anything at all in the video that identifies the original agency, because if the original if the video says, "Hi, I'm Bill Brown from Bill Brown Real Estate, and we're showing you today this property," well, there'd obviously be an argument that that video may have been the cause of the sale. But if it's simply a video which shows the scenes of the property and nothing else, then that would be more difficult. And then the question would be, well, was that video the cause of the sale, or was it that the person came and inspected the property and decided to buy?
Right.
All right.
Yeah. Okay. The other question there is when an agent runs an auction and he himself or they bid it up without anybody registered for that, just to keep the auction going, would that person who was selling the property be required to pay for that auction, the auctioneer, or is it regardless of what happens, the auctioneer's there? If nobody comes in, you've still got to pay for that auctioneer, you know, when they charge you for an auction for a property?
Well, if there's been an auction arranged, if you've signed a contract to have your property sold by auction, even if there's no bid at all at the auction, you've still got to pay the auctioneer. So the result, and again, unless, and I've never seen a contract like it in my life, unless the contract with the agent said that unless we sell your property at auction, you don't have to pay for the auction. I've never seen that. So if you've signed up a standard appointment to engage the auctioneer, there's normally an agreed fee for the auction in that in the agreement between you and the auction and you and the real estate agency, and any of the expenses in there that are properly incurred need to be paid. It is, by the way, illegal to pluck bids out of the air. The auctioneer can make an auctioneer's bid or a vendor's bid to pass the property in, but it's certainly regarded as unethical to simply pluck bids out of the air at an auction.
Well, that's a key issue, because what tends to happen in some cases, this isn't my case, but this is something that people that I know that need a little bit of advice. I think they need to chase it up. But you know, when they then turn up and let's say, for instance, there's a property for $700, they put it on for $750,000, and the auction's bid only, you know, just nobody involved, just the auction bidding it up, gets to online to $650. As well, look, that's what your property's worth, because obviously they just want to sell it and get that moved on. So that's another question. Like, you know, is that ethical? Can they do that? That happens at auctions quite a lot, Barry. In that you know, you might have the property have the reserve price at $750,000, but the best bid for the property is $650,000. So the vendor then has two options. They can either agree to accept that lower bid and the property is sold under the hammer under auction conditions, or the agent will say we'll reserve the right for the highest bidder to negotiate with the vendor. So it's not uncommon for properties to be passed in at a price below. But we might have to leave it there, Barry, if you don't mind. You've been very clear. Thanks, John.
No trouble at all. All the very best.
Okay, John.
The time on for CRB, 19 minutes past 9.
And we have quite a few callers, so I'm going to pop Rose on the phone.
Good morning, Rose. How are you today?
I'm good, thank you, John. John,
good. How can we help?
Enduring power of attorneys. If you've ticked the box where it says people can sign immediately, does that mean immediately, or if you're still competent, can that enduring power of attorneys still sign for you?
Yes, they can. If it says if you've ticked the box for immediately, and the overwhelming majority of powers of attorney that are made in Queensland will provide that the attorney can sign immediately. The reason for that is that if you, for example, were overseas on holiday and you can't sign something, but something needs to be signed, if the power of attorney says that it only comes into effect when it's shown that you've lost capacity, well, clearly when you're overseas you haven't lost capacity. So the other side of it is that you obviously should only appoint people as your attorneys that you're totally confident that they will do the right thing. So even though it says can sign immediately, you know that they wouldn't do it. The other way of protecting against that a little bit too is that if you leave the original of your power of attorney with your lawyer for safekeeping, and then the attorneys have to get in touch with the lawyer if they're going to use the power of attorney, and all lawyers have a practice, or most lawyers, certainly our practice, has a practice of independently confirming that the person has lost capacity or that they want the attorney to act under the power of attorney. All right. Then?
And can somebody else be added to that my form? Can I add that?
No.
Because I have so I'd have to make out a whole new one, because one of my sisters is quite sick, and I'm just concerned to put pressure on her for signing things if something happened to me, because I'm elderly too. And
so unfortunately you've got to do a new power of attorney there, Rose, but they're not hugely expensive. Normally you'd be looking at around about $250 to do a new one.
All right. Okay, John.
Okay, then.
Good. Yeah, thank you for that. Okay.
All the best. Bye now.
And, John, we have Bill on the line.
Good morning, Bill. How are you today?
Oh, good, thank you, John. Two questions. Firstly, the procedure for having a summons issued. Letters of demand have brought no response. So can the amount of the summons be somewhat different to those letters of demand?
In what way?
A higher figure, because something else has been discovered that needs to be recovered.
Yes, well, look, there's probably no reason why you can't issue the summons with a higher amount on it. Are you going to be issuing these proceedings in which court? Is it going to be a QCAT matter?
No, I don't think so.
So it'll be a higher jurisdiction. Will it magistrate or district court?
Yeah, probably magistrate.
Right, okay. Yes, well, look, you can, as long as it's not substantially higher. There's no prerequisite, by the way, to issuing a letter of demand before you issue a summons, unless the contract between the parties provides that will occur. But no, the short answer is no. There's no reason why you can't issue at a higher figure.
Okay, the other question is, in medical records of a deceased person, is there any grounds on which the medical practice can decline to release that to the family members?
Well, the only party that they can release those records to, that they're legally obliged to release them to, is the executor of the will of the deceased. Or if the person didn't have a will, someone who's been appointed as the administrator of the estate.
Yeah, so executors are entitled to receive it, and they can't raise any grounds to withhold.
No.
All right, that's very good. Thanks, John.
Okay then, Bill. All the very best. Time on 4CRB, 24 minutes past 9. The Law and News program, 55208888, the number. And Cole, have we got another caller there?
We do. We have Terry on the line.
Terry, good morning, Terry. How are you today?
John, it's good to see autumn finally arrive.
Aha, very nice indeed.
Look, that last gentleman was interesting. Why would you need medical records anyway from someone that's died?
Well, maybe
there's some
question. Maybe there's some question about what was the cause of death that needs to be investigated.
So it'd be political, yeah.
Or maybe there's some question that the person died as a result of medical negligence.
Okay, that's fine.
There could be a range of reasons why someone might want medical records. Although that being said, look, in the thousands of estates that I've been involved in administering, I think I could count on one hand the number of times we've asked for medical records.
Yeah, that's what I thought. Look, DIY probate on a Queensland property. I believe that goes through the Supreme Court.
Well, if it's just real estate,
yes,
Terry,
it is.
You don't need probate. So, is this a record of death, or is it a joint tenant has passed away, or is it the owner of a property has passed away?
The owner of the property's passed away and goes to the siblings.
All right, okay. So that would be. Is there other assets in the estate that will require probate?
No. It's just a property that has to be transferred to the son and the daughter.
All right. Well, if that's the case, then you can do what's called a transmission by death. Was there a will left?
Yep.
Okay. Well, if there's a will, you can do a transmission by death of the property into the names of the beneficiaries. The titles office will require the original of the will to be produced. So you want to make sure that you've dealt with all other assets before you do this, because once they get the original will, it's a bit of a procedure to get it back. So, but if that's all you've got to deal with, then you can do a transmission by death. It's a fairly straightforward process, and certainly doesn't involve the considerable expense that would otherwise be involved with probate.
You can't DIY that yourself. I went to the magistrates' court, and they just put me on to the Supreme Court, and I thought, no, while you're on, I'll give you a buzz. Didn't make sense to me, but anyway.
Yeah, well, you were asking them about probate, so the question was the wrong question. You're talking about transmission of a property as a result of death. So the place you need to be going for that, Terry, is to the titles office.
The where?
The titles office.
Titles in Brisbane.
What do they call it? No, there's one at Robina. They call it, I think it's now called the Department of Natural Resources and Titles or something or other, but it's at Robina, just near the Gold Coast City Council's precinct there.
Oh, okay.
But if you just look it up, if you just Google, they're open all the time. There's probably some restrictions on access with COVID at the moment, so you might be well advised to give them a call before you go in.
That's fine. I appreciate that. Look, just another question. I think the gentleman's name was Baranta that bought out a DIY conveyancing book years ago.
Belander.
That's the gentleman.
Yeah, Rob Belander.
Is there anything new now? Is there any updated versions of that at all you can buy?
Not that I'm aware, Terry.
Okay.
But certainly I can tell you the process for conveyancing has changed considerably. I did a lot of property work for, probably 30 years of my career, and I would even be reluctant to undertake it because it's changed so significantly. But I'm not aware of any new thing that's come out. You could, possibly take a look on the internet. That might help. All right.
Thanks very much. I appreciate that. Thank you very much. Bye-bye.
Okay, Terry. All the very best. Cole, any more calls there?
No, the board's clear.
We're pretty well clear. All right, so we've got maybe just a couple of minutes left of time, and I had a whole raft of things down that I intended to speak about today. Probably the major one that I was concerned about related to the extensive reporting of marriage breakdowns over this time with the coronavirus and incidents of domestic violence. I'll talk more about it next week if we have time. But just to bear in mind that if you are going through some strains at home at the moment in your relationship, there is always Lifeline that you can call. 13 11 14 is their phone number. That's 13 11 14 to discuss your current situation. They might be able to recommend counselling or something else that you and your partner can undertake to try and assist if things are proving to be a little bit difficult. And, of course, don't forget that if you are presently being subject to domestic violence with the restrictions at the moment, you can always ring 1-800-RESPECT. That's 1-800-RESPECT, RESPECT. That's on the dial on the phone number is 1-800-737-732. So that's 1-800-737-732. I'm John Fradgley from the Bell Legal Group. It's been great to be with you this week for another program of The Law on You, and I'll look forward to being back again next week. But as always, until next week, it's goodbye and God bless.